third part of the lesson, and I'm asking you to like our YouTube channel. Still, the name is LexClassroom. And I'm also advising that before you continue watching this third part, you should have watched our first and second, so that your learning is continuous and you can relate to what I am talking now. Now, in this lesson, I will be talking about the prohibitions, the penal provisions, and also the salient points of the law. These are my personal preference, and this is my way of presenting the law in the most simple way. Now, we begin with our first set of prohibitions. Number one, the kasambahay should not be charged of the recruitment and finder's fees. The one being charged here is the employer. And to require the kasambahay to make deposits in case he or she would cause damage during the performance of the domestic work in the household of the employer. Now, it is also prohibited to place the kasambahay under debt bondage. This means that if there's a loan being incurred by the kasambahay at the onset or in the beginning of the contract, and also the loan is indefinitely the payment of the loan is indefinite, and there's no exact period as to when should be it be considered as paid off. And the the employer is not allowed to employ any person who is below 15 years of age. This will be a violation of our child abuse law, and also it means that one the child is being employed illegally, and that's why it is related to our first it's related to the second part of the lesson, in which the pre-employment requirements mentioned about the passport, the birth certificate, or any document that would show the real age of the person being employed. Okay, let's go on now, or move on now. The kasambahay should not be assigned to any work, or like in commercial or industrial or agricultural enterprise, and the pay is below or lower than the minimum wage of those workers in that industry or in that field of work. Now, it is also not allowed to deduct from the wages of the kasambahay any deduction that is not allowed by law. For example, would be deducting from the just in case the kasambahay is has made a mistake and it has caused damage on the part of the employer, is like for example in case of the food delivery and there was a delay, and the employer changed his mind that he will not be paying he will not be eating the food being ordered, and the cost of the food will be charged to the wage of the kasambahay, then that's not allowed. And the payment of the wage should be in cash payment, and promissory note or coupons or tokens is not allowed under the law. Another prohibition is that to charge um, the any amount from the household in case of additional or temporary work performed outside of the household of the original employer. This means that, as mentioned in the second lesson, that the employer is not prohibited from assigning the kasambahay to another household, but what is being prohibited is that the wage rate is lower than the minimum, and second, the employer is charging that second household a fee for having that temporary work being done by the kasambahay. Then it's not also allowed to interfere the freedom of the kasambahay to dispose the wages, and also to in a way compel, force the kasambahay to purchase items, merchandise from the employer or any store or services of such employer. Now, this is a way of indirectly controlling the disposal of the wages of the kasambahay. And again, you have to remember this. Anything that relates to the disposal and withholding of the wages is not allowed. and even to vitiate the consent of the kasambahay in giving up part or portion of the wages he or she received, and termination of the employment beyond the reasons allowable by law, as already discussed in our second part, is not allowed. And in case one violated a provision of this kasambahay law, then that person will be fined 10,000 or to 40,000 depending on the findings of the court. And you have to remember that this is without prejudice to the filing of the appropriate civil or criminal action by the aggrieved party. So the provisions of the revised penal code and other special penal laws, example RA 7610 or the child abuse law, would be applicable. So aside from the conviction of the on the violation of Batas Kasambahay, the person is also could be convicted under the revised penal code or other special penal laws. It's the DOLE, or the Department of Labor and Employment, which has jurisdiction over the workplace of the kasambahay, um, to resolve the cases on complaints or grievances complained by the parties. So you have to take note of this jurisdiction because this might be asked in your civil law, um, or in your social legislation law, or even in your human rights law. Now, among the salient points of the law are as follows. In case of emergency, the cause of the communication to have contact with the outside or third persons involved in the emergency, the kasambahay is burdened with such cost. But the employer can waive the cost of the communication, and I think it's better and it's more humane to do that. That's just my personal opinion on the matter. And if you remember the rule on confidentiality and privilege information, and the prohibition applies even during and after employment, non-disclosure of such. But the same could be admissible if the suit involves the employer or any member of the household relating to the following crimes. And you have to take note of these types of crimes because this is really applicable in your criminal law. And you remember the rules on evidence also, that any privileged information obtained, that's a general rule, is considered inadmissible. Except, again, remember these 4 types of cases mentioned in the law. Now, if the employer is convicted against of any offense against any working child, like 15 years old, below 15 years old, the penalty should be 1 degree higher. So it means it modifies the penalty or the circumstance, and it should be the employer is prohibited from hiring a working child. Based on my observations, since the law does not make a qualification up to what extent the disqualification would be, then this is considered as a perpetual disqualification for the best interest of the child. Now, it is TESDA that will facilitate in the access of the kasambahay as to additional training or the enhancement or even in alternative learning system. Now, the kasambahay and the employer could, again, it's related to the allowance of the law in which the employer is allowed to assign the kasambahay to another household temporarily. So that's a qualification of the law. And second requirement, there should be an additional payment and it should not be less than the minimum wage. And the kasambahay is entitled to 13th month. And for one to be entitled to 13th month pay, he should have rendered at least 1 month of service. And the kasambahay is entitled to a pay slip, and the pay slip must show the deductions, and because it's the employer's responsibility to provide even at all times. This is what the law says. The employer shall also keep the copy of the pay slip within a period of 3 years. Take note of that. And the kasambahay who rendered at least 1 year of service, he is entitled to a service incentive leave of 5 days with pay. But you have to remember the limitations. The law provides that the unused portion of the service incentive leave is not cumulative or cannot be carried over to the next year and is not convertible to cash. So if you know a kasambahay, you better tell them that they should use up their service incentive leave, because there's no point of accumulating them, thinking that it will be carried over to the next year. And another set of salient points would be, if the kasambahay has already rendered a service of at least 1 month, then he or she is entitled to the benefits, SSS, PhilHealth, and Pag-ibig, and all the benefits under those laws. And also, as to payment of the premiums on SSS, PhilHealth, and Pag-ibig, then it should be shouldered by the employer. Now, that is when the salary or the wage is below 5,000. But if it's 5,000 or above per month, then the kasambahay has to contribute. Now, in case of abuse, it's going to be the social welfare officer of the municipality or city, or a social welfare officer from DSWD in coordination with the barangay officials, that will cause the rescue of the kasambahay. And also, the kasambahay is entitled to a certificate of employment, and the certificate of employment must be issued within 5 days from the request, which shows the nature, duration, and work performance of the kasambahay. And you have to remember that the date of approval of the law, January 18, is also considered or celebrated as the araw ng mga kasambahay. I just hope that you learned so much from this 3-part lesson, and you share it to those people who you know who could benefit to the knowledge, especially the employer or the kasambahay you know, and especially those law students who are being contained in their houses. And I hope that you are still doing your part, learning and making some readings, so that despite this situation, your drive to become a lawyer, your desire to fulfill your dreams are still intact. And I thank you for your attention, and I hope to see you in the next lesson. And please like our YouTube channel again. And I want to make an announcement that our 3rd lesson would be about checks, or the negotiable instruments law, but I will focus on checks, and BP 22 I will combine the criminal and the civil liability or aspect of a check. Okay, I hope you look forward to the next lesson, and have a good night. Be safe. Bye for now, and thank you once again.